Welcome back to another Senior Learning Institute's educational moment, where older adults and their loved ones turn for honest and straightforward information. In just a few minutes, you'll enjoy bite-sized, easily digestible nuggets of knowledge, empowering you to make the right decision the first time. So without further ado, here's our founder, certified senior advisor, seniors real estate specialist, nationally syndicated podcaster and speaker, the advocate you can trust, Mr. Ted Gottlieb.
Welcome back to another Senior Learning Institute educational moment. Our topic is guardianships and conservatorships. Our guest is Debra Schuster. Deb is an estate and elder law attorney specializing in elder and adult mediation. Deb, thank you for sharing your insight and experience with us again. Let me ask you this. We're going to just get right to it. Okay. What is a guardianship and a conservatorship?
So these are legal proceedings in the probate court of every county throughout the United States. So the probate court is a specific division within the circuit court that deals specifically with incapacity and issues relating to wills, trusts, distribution of assets, and creditor claims. So when someone does not have durable powers of attorney, which have been the subject, I know, of many of your other wonderful podcasts, the only other option, if someone's incapacitated and needs someone to make financial and healthcare decisions for them, is to have someone petition the court seeking to have a guardian and or a conservator appointed. So a guardian is the role that the court assigns to someone who's going to be responsible for making personal care decisions for someone relating to healthcare, safety, medical care, where they live, all of those personal care decisions, medication decisions. The conservator is the role that the court assigns to someone to make financial decisions for someone, to pay their bills, to pay their taxes, to ensure that their assets are secure. And it can be the same individual appointed in both roles. It can also be different individuals appointed in those roles. Additionally, if someone does not have a family member or friend that petitions the court seeking to be appointed, there is an office in every probate court called the public administrator that is responsible for serving in these capacities if there is no one else that is qualified, eligible, and available to serve.
Got it. So what is the process to apply to the court for this?
So someone has to first hire an attorney, unfortunately, and file what's called a petition, which is drafted by the attorney that essentially explains to the court why a guardian and or conservator is needed. And I keep saying and or conservator because someone may just need a guardian. If they have a trust, they will not need a conservator, because if someone has a trust, which is a document that appoints someone to make financial decisions for them, entitles as many of their assets as is legally possible into that legal document, the court will not require a conservator, someone to manage their assets, because they already have a trustee appointed. Additionally, if someone only has Social Security income, the court will not require that a conservator be appointed, because if someone is what's called the representative payee, that means responsible in the eyes of Social Security and has been appointed in that role, they're then answerable to the federal government to handle that person's Social Security payment. So the court does not require a conservator. But if someone does not have a trust and does not have a representative payee, or has a representative payee but also has other assets, a guardian and conservator are going to be required. And so that petition explains to the court why a guardian and or conservator are needed, because of someone's either physical, psychological, psychiatric diagnosis, And then also, in addition, there have to be what's called physician interrogatories, or questions that the court requires be answered by the treating physician that are filed with that petition, to have the court then come up with a hearing date, because there has to be a hearing in Missouri for the appointment of a guardian and conservator.
Well, so it sounds like it could be a long, drawn-out process and maybe even a contentious process.
Well, it doesn't necessarily need to be either. So right now, unfortunately, because of the health situation we're all in, the court is only having hearings when there is a true emergency. So we're filing petitions to have guardians and conservators appointed, but those hearings are being scheduled off into the summer. If someone has an emergency, we are filing a petition with additional documentation that explains to the court why there is an emergency, and a hearing really needs to be held as soon as possible. But ordinarily, absent the health crisis that we're going through, St. Louis County really, on their court calendar, from the date of filing the petition and the physician interrogatories, is scheduling hearings within a month to 6 weeks. So it's really not that far into the future. The city of St. Louis has fewer cases that are filed, so they really run anywhere from 3 to 4 weeks from the date of filing to the date of the hearing. In terms of contentiousness, we do everything possible. When I say we, it is attorneys that handle these types of cases, do everything possible to try to have family members agree to the person that is seeking to be appointed. Because if there are family members that are arguing about whether the individual actually needs a guardian or conservator, or who is the most appropriate to serve in that capacity, then certainly it can take months and months to resolve these issues, and certainly thousands of dollars, which very often is in no one's best interest, and certainly just causes an enormous amount of stress and heartache for the family when people cannot agree on these things.
Right. Well, even if I'm the senior and I don't want to give up my rights, and I don't feel as though it's in my best interest to do so, and somebody else wants to go ahead and try to get that guardianship, I mean, I think that could get contentious as well.
It can get contentious, but that is actually much more common. And the court always requires that an attorney be appointed to represent the individual over whom a guardian and conservatorship is being sought, because they're being deprived of their rights. And I am often the person that is appointed to represent the individual over whom a guardian and conservatorship is sought, when I'm not representing the party that is petitioning to be appointed. But again, it's not uncommon for the person who is having a petition filed to have a guardian and conservator appointed for them to not want to have that appointed. But if there is a strong physician statement explaining to the court why that's needed, that usually does not cause the delay that we were just referring to. It can, because one of the rights of an individual over whom a guardian and conservatorship is being appointed is to be able to ask for another physician opinion, is to ask to have witnesses testify at the hearing, is to in fact have a jury trial if they so choose. Now, thank heaven, in the 28 years that I've been practicing, I've only had this issue come up twice where a jury trial has been requested, and thankfully that's actually not come to fruition, because ordinarily it is just the judge that hears these cases, not a jury.
Right. Is the physician required to cooperate?
So the treating physician is required to provide responses to the questions that the court needs to be answered. And we can always subpoena the physician to appear at the hearing if the physician is not willing to provide that written document, because ordinarily, if the physician provides that written document, that is instead of them being required to appear at the hearing. And because of their busy schedules, they usually don't want to be subpoenaed to appear in court. But we have that authority, and the court will issue a subpoena if a physician is uncooperative. Now, again, when we were talking about having contentious family members or a person who is opposing having a guardian or conservator appointed for them, if they're seeking a second opinion, and if their attorney opposes the opinion of the physician that first advised the court of the need for a guardian and conservator, sometimes we can have a situation where two physicians may need to come to court and provide testimony, but that again is also very rare.
Got it. We're speaking with Deb Schuster, elder law and estate planning attorney. Deb, you had touched base on the powers that the guardianship and the conservatorship have. Is there anything that we need to do to elaborate on those a little bit?
So one of the things that occurs, the guardian has the authority to determine where the individual will live based on their care needs. And the court looks at what is the least restrictive environment for the individual over whom the guardianship is being sought. And that is often determined by the physician's opinion, but also by the guardian. Once a guardian is appointed, as long as they consult with that person's physician, which they can choose on behalf of that individual that has the guardian appointed, they have to abide by that physician's opinion in terms of, does that person need assisted living? Will they be safe in their own home with care, and how much care do they need? Or do they need a skilled nursing facility? It's all based on what is the least restrictive environment commensurate with that person's care needs, but also maintaining as much independence and self-sufficiency as that person can handle. On the financial side, the person that's appointed to be conservator is required to be bonded by the court to ensure that the assets of the individual over whom a conservator is appointed are safe, so that if that conservator essentially uses that person's money in ways that the court does not pre-approve or runs off to Tahiti with that person's bank account, the bonding company will replenish those funds so that the person over whom the conservatorship is appointed does not become destitute because of negligent or illegal behavior on the part of their conservator.
Got it. Clarify for me, if you would, because I think I heard it, but it didn't register with me. How long does the authority last that the guardian and the conservator has?
Right, we didn't talk about that. So that authority lasts until the death of the individual who has the guardian and conservator appointed, unless someone else seeks to have that individual removed. And fortunately, that is not that common, but it does happen. So if there are family members, or for example, if a physician or a financial institution feels that the person that's appointed to be responsible for healthcare decision-making or financial decision-making is not making decisions that are in the best interest of the person they're appointed to be responsible for, they can make an emergency hotline call to the Department of Health and Senior Services and have an investigation of the person that's appointed as guardian and conservator. And in some cases, a petition can be filed by the state or other family members to have them removed if they're not doing the job they're appointed to do.
Got it. All right, well, I think that covers most of it. Is there anything else that you want to share with us that I've not asked you or you have not covered thus far in regard to conservatorships and guardianships?
I think the most important thing for people to realize is that if they create durable powers of attorney, and for those that a trust may be appropriate for a trust, guardian and conservatorship are often not necessary. It's only when people lack these documents that are not that expensive that are not difficult to create. If they become incapacitated, then the only other option is to go to court. But in most cases, that is avoidable. And it is absolutely in everyone's best interest to try to avoid having to go to court to have a guardian and conservator appointed, if at all possible.
Got it. And then the documents that you're referring to, the durable powers of attorney and those other documents, the trust and everything else, I know they're long lasting, but oftentimes we're told that we should have them reviewed on a somewhat regular basis. What are your thoughts in regard to reviewing those documents?
So my thoughts are, whenever there is a change in life circumstance, so a death, a birth, a divorce, if someone moves to a different state, and then certainly every 3 years to review those documents, because most people go for years without remembering who they've appointed. And very often their appointees may not even remember that they're appointed. I have clients coming to me all the time, or individuals who've been appointed saying, my aunt appointed me under her durable power of attorney and never told me. And I'm really not thrilled about serving. So it's really important to not only check your own documents, but also double check with your appointees if they're still willing to serve, and also to talk to your physician about your choices, particularly under your living will, if that physician is comfortable supporting your choices, because physicians have the legal right to not honor someone's end-of-life treatment wishes if they themselves have strongly held religious beliefs or moral convictions. So it's very important to talk to your physician to make sure they will honor your wishes, as well as your appointees.
That's great information. I appreciate that. And for our audience, this is information, or this is a subject that really needs to be dealt with. It's, I consider it part of my legacy. I want to make sure that I have all my ducks in a row and that I help my children make the decisions that I want to be made on my behalf, and it takes the burden off of them. So I highly recommend that you talk with Deb or seek out an estate or elder law attorney to have these conversations. You will feel so relieved that you've done it. I can't tell you how many children of older adults that I've worked with who, after their parents have passed away and have dealt with these type of situations, they're the first ones to run to the estate planning attorney and the elder law attorneys to get their ducks in a row so that they don't have to pass this on to their children as well. So please take the advice and seek professional help when it comes to this, because it will make you feel better, believe it or not.
And it's a gift to your children. It really is.
Oh, absolutely. I agree wholeheartedly. Well, Deb, thanks for sharing this valuable information with us. What's the best way for someone to get a hold of you if they want to have a deeper conversation in regard to this subject?
Sure. To contact me through my law firm, and my telephone number is 314-244-3693. My email address is dschuster@pcblawfirm.com. And my law firm is pcblawfirm.com. It's Paul Kamazine in Blumenthal. And Ted, I can't thank you enough for the wonderful work that you are doing and this essential information and service you're providing to people, because it is so important.
Well, thank you. I appreciate you sharing that, Deb. I want to thank all of you again for listening to this Senior Learning Institute educational moment. At the Senior Learning Institute, we strive to provide straightforward and unbiased information, the information you need to make smart decisions the first time. We connect older adults and their advocates to the resources they need, from aging in place to selling the home in any condition, estate and financial planning, in-home care, estate sales, clean-out services, you name it, anywhere in the country, really anywhere in the world, we will connect you without cost or obligation. To learn more, please visit us at theseniorlearninginstitute.com. Until next time, I'm Ted Gottlieb, Certified Senior Advisor, Seniors Real Estate Specialist, and founder of the Senior Learning Institute.